Thank you everybody for coming along to today's panel. I note that our other virtual attendees are gradually exiting the waiting room and joining the main meeting room. It's very nice to see you all. I'm sorry we're not over there with you, but with the wonders of modern technology, we're able to join you in this way. My name is Chester Brown. I'm Professor of International Law and International Arbitration at the University of Sydney. I'm also a barrister at 7 Wentworth Selborne Chambers in Sydney and an overseas member of Essex Court Chambers in London. I hope you are all enjoying Washington Arbitration Week. I guess it's now the sort of coming up towards the end of what's been a terrific week of events and activities. I also hope your respective teams are progressing well in the World Cup and you're managing to juggle your commitments to attending events as part of Washington Arbitration Week with following your team and cheering them on over in the Middle East. Now, today's panel session is on the draft guidelines on the prevention of investment disputes and the defence of claims in investment arbitration. The draft guidelines are really an evolving outcome of a conference that was convened in Singapore a number of years ago, way back pre-COVID in 2018. And the objective of that conference in Singapore was to initiate a dialogue that would lead to a set of best practices and non-binding actions that states may choose to take to prevent investment disputes and also to improve their readiness and their defence in investment arbitration claims. We have an excellent panel for this discussion today, and I'll just take a few minutes to introduce our panelists. Although none of them really need any introduction, they'll be well known to all of you. They're all very highly respected members of the international arbitration community. Beginning with Jeremy Sharpe, who's also joining online from Ottawa. Jeremy is an international arbitrator, international law consultant, lecturer in law and senior fellow of the International Claims and Reparations Project of Columbia Law School. He was previously a partner at Sherman & Sterling's international arbitration practice based in London and Paris, where he advised private and sovereign clients on diverse matters of international dispute settlement, public international law and investment arbitration, law and policy. Prior to that, he served as Chief of Investment Arbitration in the Office of the Legal Advisor at the US Department of State, where he represented the United States in investor-state and state-to-state disputes arising under international investment agreements, including NAFTA and CAFTA, and he also advised on the negotiation of those agreements. Before his service with the State Department, he practiced international arbitration with White & Case in Washington, D.C., and also was a clerk at the Iran-US Claims Tribunal in The Hague. Our next speaker is Nanas Molavi, who is a barrister and arbitrator at 20 Essex in London, also joining online via Zoom. Nanas specialises in representing governments and private clients in commercial and investment arbitration. She's acted as counsel on behalf of both investors and states in several investment and commercial disputes, and she's also been appointed arbitrator in a number of ICSID cases. She has extensive experience in advising governments and international law organisations on international investment law issues, including the development of model bilateral investment treaties, negotiating positions, sovereign guarantees, foreign investment laws, and a range of other matters. She's a graduate of Cambridge University and is qualified as an attorney in New York, a solicitor in England and Wales, an advocate of the High Court of Pakistan, and a barrister in England and Wales. Our next speaker is Tim Feary, who is a partner in the Washington, D.C. office of Arendt Fox Schiff, LLP, and co-leader of that firm's international arbitration and dispute resolution practice. And I take this opportunity to thank Arendt Fox Schiff for hosting the event for those who are attending in person today. Tim's practice focuses on international arbitration, international claims and dispute resolution work, including the representation of states, investors and private parties in international commercial transactions. And Tim is currently involved in representing both private investors as well as sovereign states in investment treaty claims, as well as states in pure public international law claims. Last but not least, Jose Antonio Rivas, who is a founding partner of X Strategy in Washington, D.C. and Bogota. He's admitted to practice in the District of Columbia and the Republic of Columbia, and he works as a counsel in investment and commercial claims, also served as arbitrator and advisors on public international law issues. Prior to founding X Strategy LLP, he was a senior associate at Arnold & Porter, also in Washington, D.C. And before working in private practice, Jose Antonio was the Director of Foreign Investment at the Colombian Ministry of Trade. He led the negotiation of around 15 bilateral investment treaties during his tenure there, including the negotiation of the United Kingdom-Colombia bilateral investment treaty, where I was privileged to be on the other side of the table and negotiate with Jose Antonio. And of course, we're all grateful to Jose Antonio as being one of the co-founders of Washington Arbitration Week. So it's thanks to Jose Antonio and Ian Laird that we are having this series of events. Now we have obviously still a lineup to speak about the issues that are raised by the draft guidelines. And I'd like to invite Jeremy to say a few words first. Jeremy would like to perhaps say a few words about the organisational issues for a state in preparing to defend investment claims, thinking about some of the institutional issues that states need to think about to best prepare themselves for the evil event that an investment claim might arrive through the post. Over to you, Jeremy.
Thank you very much, Chester, for the kind introduction, and thank you, Jose Antonio, and the other organizers for organizing this. It's a real pleasure to be with some of the pioneers of some of the developments in this area about state measures to defend themselves in ISDS. When I was thinking about this topic, I was reminded of a conversation I had with a colleague from Eastern Europe who worked for the government, and she said, you know, she represents her state in ISDS proceedings and in other courts like the European Court of Human Rights. And she said, at the European Court, I have a formal role. I'm the agent. My office in Capital organizes itself around this institution. And everyone in Capital and in Strasbourg knows that her office is in charge of this issue area. And she periodically meets with other state agents to exchange views and best practices and so forth. But she said, you know, for ISDS, it's totally different. One feels that you're on your own with little support at home and abroad. And I think that's not an uncommon feeling for many state officials. You know, ISDS is ad hoc, it's decentralized, and state officials, they often face similar problems, but they don't have similar channels to find solutions. So they have to create a framework for ISDS for their own state. To my mind, I think as states think through these issues, there are 5 general categories or prerequisites for states to organize themselves, at least as I see it. The first is simply standard operating procedures. Excuse me. The state needs some processes in place to ensure that the relevant state officials, they know about these disputes, they receive the information about these claims, because I think it's not uncommon that investors have no idea who the point of contact is within a government to discuss a dispute or even to send arbitration documents to. And so sometimes notices get filed away. They never see the light of day again. No one within the government knows about these claims until the arbitration is well underway. Or sometimes investors copy various ministries. They may even copy the president or the prime minister on a notice of intent or a notice of dispute. So everybody knows, but no one takes action. And so you have a problem where the states have taken the trouble to negotiate, for instance, cooling off periods to learn about these disputes, to potentially settle claims, but these are wasted potentially by inattention or the lack of standard operating procedures for dealing with these claims. The second prerequisite, at least as I see it, is authority. States have to have laws or regulations, directives, decrees, to ensure that the responsible government official has the authority to take action, to take steps to represent the state effectively. And here, states are advised to to appoint a lead state agency, as Jose Antonio has long written about. And I think the lead state agency should have broad authorities in matters of ISDS. It can be a primary interlocutor for foreign investors. It can be a central resource for government agencies in dispute prevention and mitigation and management. It can engage in mediation, conciliation, settlement agreements. It can get information about the cases, the documents they're necessary for the case, the witness testimony that's necessary to defend the case. It can hire counsel, maintain records, archives, develop a model bid. It's all the things it needs to do to formally represent the state in international investment arbitration. The lead state agency should have these authorities in law. The third thing is coordination. States obviously have to coordinate to defend themselves effectively. And I think of this as internal coordination and external. So internally, of course, you have loads of government entities that can give rise to a dispute. And so state counsel need to communicate with them, educate them about the risks, about the substantive bit obligations and so forth, so that the government is working together seamlessly when problems arise, when disputes arise, when arbitrations are underway and so forth. And the second and equally important is there needs to be external coordination. The state counsel have to communicate with other treaty parties, potentially to find out about various claims, issues, non-disputing parties, and so forth. And of course, to hopefully develop best practices. The fourth, I'll just note, is counsel. Obviously, these arbitrations often are high stakes, and the state interests have to be defended. I think states have developed generally three models for representing themselves in ISDS cases. You have some instances where the states represent themselves, like Canada or the US or Spain or Argentina. You have, on the opposite end of the spectrum, you have states that really outsource their ISDS cases more or less entirely with no formal role for state counsel. And then you have something in the middle, a mixed model like Mexico, where there are state officials who are formally involved, but they still may rely on outside counsel for their advocacy or other specialized skills. And the final thing is money. Investment arbitration obviously is very expensive. It takes a long time, and states need adequate and consistent sources of money to pay these high costs without having to go through special budget requests. And I think if the states haven't sorted out at a minimum these 5 things in advance, they're really going to be on their back foot throughout the arbitration and can make it much more difficult for them to prevail or to lose in a manner that would have been worse if they'd had these institutional arrangements in place from the outset to help defend the state effectively. So perhaps with that, Chester, I'll stop there.
Great. Thank you very much, Jeremy, for that overview of the best practice for a state. Nanas, I believe you had perhaps a question, a comment, or a question for Jeremy, just to follow up on some of his points.
Thank you, Chester. I was going to ask Jeremy about the secret, and here I'm referring to the secret of why the United States of America has been successful in defeating all investment treaty claims. So I was just wondering if you knew what the magic elixir was, and if you could share the recipe, then we could bottle it up and send it across to all the various countries of the United Nations.
Thank you, Nanas. I'm reminded when I took over the position of Chief of Investment Arbitration, one of my predecessors called in to congratulate me, and he said, "I'm sure you'll take the office to new heights." And I said, "Look, when you've won every case, there's only one direction you can go." But I think there are several reasons. One is just the United States is a very litigious society, and so all of the regulatory agencies operate under a threat of litigation all the time, and this has a kind of disciplining, perhaps, influence. But more importantly, Nanas, going to these prerequisites, I think the United States has been very lucky that when the investment arbitrations came about, it already had many of these institutional arrangements in place because of the United States State Department's longstanding role in international litigation, plus litigating scores and hundreds of claims at the Iran-US Claims Tribunal. So we had the authorities in place, in the sense that the State Department's legal office was the lead state agency for these things. We didn't have the standard operating procedures in place immediately, but they were incorporated into our treaties so the investors knew where to send documents. So we immediately were aware of disputes or issues that arose. And similarly with coordination, I think working groups were established within the US government. And crucially, going back to the external communication point, the Mexican, Canadian, and American governments began working very closely when disputes would arise. So you see loads of non-disputing party submissions being made by the different countries in the NAFTA context. You see a joint interpretation on a key issue. And I think that's really helped allow the states to ensure that the views of the three treaty parties are put to tribunals and try to keep the law, at least in that regard, on a sensible track. Counsel, again, the United States was advantaged in having an existing office with experienced counsel to defend the US. And money, we had an existing international litigation fund in place for the Iran-US Claims Tribunal, which was broad enough in authority to allow the investment arbitration team to then tap into that for experts and so forth. So the United States doesn't have everything, but I think it has the basic institutional apparatus in place to really ensure that it's able to defend itself very well in these cases. And a lot of states just don't have all of these advantages, or didn't have these advantages from the outset. And I think could learn from the experience of Canada, the US, and various others that have put these in place to try to ensure that at least they're on the front foot when they're defending these claims.
Thanks very much, Jeremy. I might turn now to Nanas again, and maybe thinking about the very early stages of a threatened claim, and the steps that a state can take to be aware that a claim is imminent. Nanas, I'd like to offer some thoughts.
Thank you, Chester. And I should probably start by saying that any resemblance to any real case, living, dead, or suspended, is entirely coincidental. There is a rather long chronology between the signing of the treaty and the arbitration claim. And I've been revisiting those chronologies of various cases in my mind to see what could have been done differently, perhaps, at each stage, to avoid the dispute, to prevent it, perhaps, or at least to manage it in a better way. And I'm not entirely sure whether it's Jose Antonio's Colombian heritage, the trigger word chronology, or the sheer magical realism of some of the cases we deal with. But I kept thinking of Gabriel Garcia Marquez's novella, Chronicle of a Death Foretold, as I was looking at this chronology of arbitration cases. And I guess for those of us unfamiliar with that book, it really, the narrator in that book talks about the fact that never was a death more foretold, yet no one was able or willing to stop it. And I'm afraid some of the cases, indeed the chronology of events, make one think of similar emotions. And I don't want to go into too much detail of all the milestones in the case, but I will strip it down to the bare basics. You have, of course, the beginning, or even before the beginning, which is the conclusion of the treaty itself. And I think many of us have wished that we could time travel and go back and whisper in the ears of the treaty negotiators to just use different language. But I'm afraid that is not possible. And I don't want to tread on the toes of others that are going to be talking about the importance of model treaties and getting them right. But what I do want to point out as a practical step is that these treaties are not ancient relics to be kept in vaults and to be dusted out when the claim hits. They need to be front and center. If you have them, it is important to know what's in them and to be familiar with them so you are not unwittingly breaching them. The second sort of step in my little milestone journey is the making of the investment by the investor. And I'll come back to this later on. And a bit like Gabriel Marquez, I'm not really going to follow a chronology, even though it is supposed to be a chronicle. I will go up and down to really confuse you entirely. But I just wanted to put the fact that there is a making of an investment by an investor. But where I'd really hope there was a freeze button, and this is where I think is the moment where I would like to pause the lens a bit, is the event, the act or conduct attributed to the state that supposedly breaches the treaty. And we've had many lawyers call it the wrongful act. And this comes in many guises. It can be a one-line letter refusing $1 billion mining lease. Please do not read into these examples too much. It could be the arrest at midnight of an investor. It could be an act of parliament stopping the drilling of oil overnight within a certain distance of its coastline. It could be paramilitary forces killing terrorists and employees of a certain shrimp farm owner. It could be the police simply not turning up in time as vandals destruct certain hotel complexes in certain countries. And these are these events, and often, even in hindsight, if you speak to some of the states involved, they would tell you that this is how things are done. Sometimes the police doesn't turn up. They do write one-line letters. Sometimes the word etc. is used to define reasons why mining lease concession was refused. There is nothing personal. And if their courts were actually reviewing these letters, these actions, it would be perfectly fine. And here lies the problem. And this is why the mystery of the forgotten treaties needs to be revisited here. Because it's not about domestic law, and it's not just about domestic courts. It is about international standards. And here, it's not so much about the substance, but also the form and the procedure. Often, the how is forgotten. And often it's a how rather than why that triggers some of the treaty standards. And that's easily fixed, in my view. And here is a practical step, really. And here I'd use a very trite Latin phrase known to lawyers and John Wick fans, for those of you that are interested in that particular series. Se vis pacem para bellum. If you desire peace, prepare for war. It is in times of peace, when the war hasn't quite arisen, that the lawyers need to get involved. And it is in the writing of that letter that lawyers need to get involved. And that money perhaps is well spent defending an undefendable letter that the state might have written. It has always amazed me how little states consult legal advisors at the time they take certain conducts relating to investors. The contracts relating to those projects are vetted, but the letters rarely are. And here perhaps is really the key factor. You might say that, well, it's very hard for a state to think about all the investors that may be affected by a treaty breach. And how do we keep track of that particular element? But this is really part of the toolkit that we're all talking about. Jeremy talked about the Defense Department, the need for coordination. I would say the first step would be get your treaties in order. Know your investments and investors, and I'm happy to elaborate how an aftercare system can be set up. Consider the act or conduct that triggers the treaty. Write a good letter. Pay for that letter rather than the case that may come up. Prepare for war. to keep the peace, make sure you know what you're doing. So when the inevitable death, which some say might have been foretold, at least can be avoided in some way or form. Thank you.
Thank you very much, Nanas, with a lovely reference to Gabriel Garcia Marquez. Tim, I might pass over to you for a reaction to that, and how the author of such a letter might possibly, hopefully, avoid the fate of 100 years of solitude by having some external counsel check their homework before that letter is sent. Tim, do you have any thoughts?
Well, my first thought is, first of all, Mana, that's really thought-provoking what you've said, and I wonder why. Also, frankly, I think that you know, in spite of what I'm about, well, I'll say later, that unfortunately states they learn by mistakes, and you can tell them what you want, but you are probably not going to be heard until it's too late. So I don't know why that is. I'd be interested in your thoughts, given what you've been thinking about this for a while. But I think this, you know, learning by mistakes is very, very, very expensive, and I think, you know, why states don't wise up to it. I think those are internal politics where you know, the issues of the day are the important ones, and so they don't sort of think too deeply about other things. So part of what I will say is the rush and the pressure that a lot of developing countries are under, and so you'll see these kinds of letters that come out because they feel like they have to make some statement, but haven't thought it through. So I mean, it's not a great answer to you, but that's my sense of it.
Thank you,
Thanks,
Tim. Oh, sorry, Nanas, go ahead.
Yeah, now this is going to say that Tim, you're quite right. I think to me, sort of the answer seems to be in the investment promotion agencies. Of course, all the investment and the treaties usually are related to these investment promotion agencies, but promotion is not just about protection, and we forget the aftercare bit. And this is where I think the work really needs to be done, because aftercare involves knowing how the investment is doing and making sure that if any grievances do happen, they happen early on. And I think you're quite right that the government is huge, so it's almost impossible. You know, it has several ears and several eyes and several hands. So, you know, what happens in a port somewhere in the middle of nowhere, or what happens in a court in Mississippi, might be a bit difficult for people elsewhere to know about in real time. But I think especially when the countries are smaller and they have an aggressive foreign investment agenda, having an aftercare sort of component built in, which can then pick up on these grievances that might grow into rather poisonous disputes, and to see if the coordination can be improved. So any letters, any steps that are taken can be really nipped in the bud, I think is a practical way really to build on that existing investment promotion apparatus. So I don't know if that answers your question, but it's definitely one to put in the box, I think.
I agree, absolutely.
Thank you. I might pass over to Jeremy for any reaction. And I suppose the contrast I'm thinking of is a state which doesn't have very much, if any, experience in dealing with or facing investment treaty claims, and, you know, maybe completely oblivious to what they are, despite the fact that that state might have signed a number of bilateral investment treaties, and comparing it with a state such as the one you've represented and worked for many years, where there was a clear sort of apparatus in place and lead agency and good interagency coordination. I mean, so it's almost for that state which has never faced an investment treaty claim before, whose government officials may be ignorant of the existence of investment treaties, let alone what they mean and what they could result in for the state. That state official writing that first letter really is on a hiding to nothing. But Jeremy, any reaction from you?
Yes, thank you, Chester, and thank you very much, Nanas. I think that's a really crucial point. In fact, I'm reminded of a conversation with another lawyer from an Eastern European state who said this, to his mind, is the biggest challenge he faces, is that they have a number of international investment agreements, loads of entities that could give rise to disputes, but how does he communicate the substantive BIT obligations across the government? And he just doesn't have the resources, and yet this responsibility seems to fall upon him. I think there have been some efforts. There's some domestic efforts. States like Canada have a guide to municipalities to try to educate them about the NAFTA obligations. And they do outreach to these various provinces across the country to try to educate them, as well as the federal agencies. Now there are some initiatives like Jan Calamida's pamphlet for ASEAN that could be translated and could be sent to different state officials across the government to sensitize them to these BIT claims. But it's always going to be an uphill challenge, and it's going to require a lot of resources. The other thing that states, even like the United States, which does outreach and and makes an effort to educate officials about the BIT obligations, there's a legal or constitutional problem because we have subnational entities like states that can give rise to disputes, and you don't have the same perhaps a relationship of control over these entities. And there, I think it's really important to have outreach to try to educate them, to have confidence building measures when disputes do arise, so that they cooperate with the federal government to make sure that when the federal government is representing the state measures, that full cooperation is provided by the state, and there's a spirit of cooperation and a sense that it's the single actor that has to defend these measures, even though they might come from a subnational entity. But I do think this is one of the central challenges, and more work by NGOs and IOs and various others within states could be more effort could be put in this area, and the payoff would be far greater than the expense.
Chester, might I come in again on this?
Please.
I just wanted to add here that in my experience in working in this area, especially with respect to developing countries, they take as creed that foreign investment is important, and the only way to get foreign investment is by signing up to these BITs. And I think years ago, I mean, I hope it doesn't around now anymore, but so they were given a BIT to sign, and they signed it, and they put it in the vault, as you say, and they're shocked when something happens because they never thought about it then. They never thought about what are their obligations under that instrument, and there they are. So one of the things that we've tried to do with and it's been successful is to get them to do an audit, figure out where are these landmines for you, legal landmines, and make sure that you understand, and this is what you were saying earlier, but understand what your obligations are, and then you have a much better chance of getting, finding a way to get issues resolved rather than going to exit arbitration or whatever it is. So there's a lot of that out there still, and they are remnants, and you're exactly right in your description of them. But there still needs work to be done to get people to be educated and to understand what these are and how they can hurt or how they can help.
I just had a quick, Chester, I just had a quick question, if I may, and I think it's to all the members of the panel. One of the things that came to my mind was whether countries where there is a high level of judicial review, so governments are used to being accountable for their acts before independent courts, is there any correlation between those countries faring better in investment treaty claims because they're just used to more accountability, or is that completely sort of off the mark?
I suppose as an immediate reaction that would seem to follow, but it could also be that there are states which have a process, an extensive consultation process in place with respect to the adoption of new measures, particularly legislation, both primary and secondary, that there's a specialised government regulatory agency that involves an impact, like an impact assessment of proposed measures. That would, I'm assuming, I don't know any research on this, but that would also seem to probably suggest that that state might be able to demonstrate the reasonableness or non-arbitrariness, for example, of measures that have been adopted if it's been subjected to a domestic regulatory impact assessment process, and that could help with or without the possibility of judicial review of executive decisions. But sorry, Tim, I just interrupted you. You're about to say something.
That's fine. Thank you.
Okay, we might move on to, sorry, Tim, I might move on to you.
No, sorry, it's just anecdotal what you're seeing out there in the world, and in the countries where I work, I don't see that correlation.
Okay, that's interesting. Well, Tim, I might pass to you now, and I think you wanted to offer some thoughts on practical issues for external counsel arising from dealing with government officials, working with government officials, some features of the draft guidelines perhaps that have caught your eye that raise practical issues. Thank you. Okay,
thank you very much, Chester, and thank you, Jeremy and Nanas, for your remarks. They're very, very interesting and allow me to jump off there. Just by way of a brief sort of background, we've been lucky enough to represent a number of governments all over the world, from the poorest to the richest, and in our work we see a lot of these countries are all different, but we see the same issues kind of popping up, especially in relation to developing countries that trip them up in their efforts to mount vigorous defenses or even to negotiate outcomes before disputes arise. And one overarching issue that really can't be ignored, and that is the lack of critical governing capacity in the poorest countries. Now it's kind of odd, at least in our experience here, is that at the highest level of executive governance, like at the ministerial level or secretarial level, they're largely populated with well-educated, capable, and talented women and men. And it's at the lower bureaucratic level, it seems that that's where the problems begin. When the ministers want something done, they'll send it down, and the reactions will be spotty or slow or inaccurate, and so as a consequence, the ministers just bypass their own bureaucracy. With the result is that there's a huge amount of pressure on this cadre. Now, in our experience, again, this is just ours, but these ministers, they work 7 days a week at all hours of the day, and we know it because we see the timestamps in their emails. And really good ministers are rewarded with additional portfolios. So about a month or a month and a half ago, we met with a minister on a Sunday afternoon, and she told us that she now had 13 portfolios under her work. Her core team is as stretched as she is, and it's simply not possible for her to answer every letter, email, or phone call punctually. It's just not going to happen. Another factor that we see that limits a government's ability to be effective in this arena is working in silos. And that is that if an investment arbitration comes in out of a project by the Ministry of Mines, to take a name, that ministry will run the arbitration and the negotiation to before that, even if they've never done it before. And so that this has two effects. First of all, it's inadequate lawyering, and it means that the government doesn't have any government-wide learning. It's all in these silos. So that's another limiting issue that we see. I want to also turn briefly about corruption. First of all, I want to make it clear that I am against corruption. What I'm about to say may make you think otherwise, but anti-corruption measures can and do stifle a state's ability to settle investment disputes. Now, the way that works is that if you've got strong, let me put it this way: the situation that we encountered was that the activists, prosecutors, and courts charged and jailed numerous ministers and functionaries to the point where nobody would take the responsibility of signing large checks. And so they were left to the only thing that they could approve were very small payments. And so it prevented the functioning of the government effectively. And I can tell you that this particular issue is still not resolved. So it's you know, when it's not done well, it can get out of hand fairly quickly, and this is an example of that. So I think, you know, when we turn to, you know, how issues may be addressed and remedied, the lack of capacity is quite clearly a very difficult issue, and it can really only be remedied over time and with a real commitment to education and keeping keeping your citizens in the country and interested in it. But I think that in the meantime, there are some initiatives like the draft agreement guidelines that can help close the gap in the meantime. So I think what attracted me in particular as being initiatives that could help in the developing country immediately is number one, the system of warning, a warning system, so that the importance there is that it gives the state time to do what it needs to do, and that means understand what the case is. Well, before that even, you know, can we negotiate that can we have a few rounds of negotiation? Even if they're unsuccessful, the state now has a much better sense of what the case is and how it might be defended. So that's very, very important, and it's something that I think states can do right away if they're entitled, if they want to. And so on the issue also of corruption, the ideas in the draft guidelines of getting groups together to to review a bit, to review a case, to make a decision on a settlement, to do it in a group, an interagency group, makes a tremendous amount of sense, because then you're not isolated. Either a ministry isn't isolated, a minister isn't isolated, and so you have this opportunity to get it done by a group that people can trust. So I think, let me just end with that, as seeing the draft guidelines as really concrete steps that developing countries can do to increase their ability to deal in this arena.
Thanks very much for those thoughts, Tim. Before handing over to Jose Antonio to respond and make some more general observations and reflections on the draft guidelines and their utility, I might just note the time, and we've got about 15 minutes left, and it'd be good to have some Q&A, both from those who are following this online as well as those who are in the room. And I might, once Jose Antonio said a few words, for those in the room who have any comments or would like to raise some points for discussion or questions, I might look to Jose Antonio or Tim to sort of direct the traffic, as it were. So a bit hard for me to see who's got their hand up. But anybody who's online and would like to ask any questions, I guess there's a chat function or a Q&A function on the Zoom that you can please feel free to raise any questions in, and we'll hopefully get the chance to discuss those. So Jose Antonio, I might just pass over to you now for any comments before we move to the Q&A. Thank you.
Thank you, Chester, and thank you everyone for their comments. I think that I would like to share a little bit of background. Chester already shared a little bit of background. 2018, when we first drafted what remain draft guidelines for prevention and readiness in investor-state arbitration. The background, in addition to that background, I'd like to refer to some of the comments that Nanas and Jeremy shared right at the beginning. What is the elixir? And the elixir is, and of course the guidelines are not meant to be an elixir by any means, but I believe that the process of the guidelines did start way back, right after Argentina had received many cases in 2003, 2002. By the time I was basically switching jobs from ICSID to Colombia to negotiate treaties and also address investor-state disputes if any were to arise. At the time, there was a very early on potential Peruvian investor ready to sue Colombia, and I was just landing on the job, and mortified because we were going to start a very heavy load of negotiations. My thought was, well, there's a few folks that I know from ICSID, and there's a few folks that I know from the State Department, and why don't we try to get their ideas? So at the time, I believe that Bart Legum was there, and David Pollock was there, and together with some assistance and piggybacking on some friendship, the idea was to create a wish list of what you would do before the case got in front of you, and implement those sort of re-engineering inside and administrative changes within a state that would get you ready for the dispute. And in addition to that, the notion of what can you do in order to prevent them. And of course, some will say you cannot prevent them. You know, unless you're Brazil, they have no BITs, you cannot prevent them because there's always going to be you know, an investor that might bring a case simply for the fun of doing it, because it might be the first case, because it might lead to a negotiation, etc. Those are not the rule, but those cases do happen. So the notion of the wish list was developed, and therefore, you know, together with Chester, we will put pen to paper to try to create a structure that would have two legs. One leg would be the prevention leg, and the other one, the readiness one. In the prevention part, the notion was that yes, you cannot absolutely prevent it, but you may want to tackle the issue through two, let's call it avenues. One would be to determine what is your level of exposure and risk as an economy. So if we're referring to an economy that is heavy on minerals and production of hydrocarbons, etc., most likely the agencies that are going to be dealing with foreign investment are the agencies that are related to mining and hydrocarbons, etc., etc., etc. So what might be a good strategy in terms of finding who may be the officials who could eventually breach an investment treaty in Singapore might not be the same officials if you are in Saudi Arabia or in Colombia. So really, there's no formulas, but the prevention should go in such a way that you have to be country specific, economic specific, to determine who might be the officials who you need to reach out to, so that you do many of the things that Tim has suggested, that Jeremy has suggested. Well, and Manas. So yes, they're not, BITs shouldn't be archaic documents. When referring to one of the Albania cases, I believe that Professor Crawford basically was consulted by an Albanian public servant in Albania, and the treaty hadn't been sort of addressed, and there were boxes and boxes piling off for many months at one side until he was consulted. So they're not relics, and because they're not relics, the public servants who may mostly deal with foreign investment would need to be educated as to what are the obligations, and this is education not in terms of they're not going to become counsel, but at least they will know what they should not be doing. If you have a clause on regulatory expropriation, or if you have a national treatment clause, because you know, as we all know, the breach can be done by the mayor of a small town, or it can be done by judicial court, etc., etc. So that education is key. So the components, I mean, to be very, very brief on the prevention side, are basically identify who are the main actors within the state that would need to have that awareness. Why? Because then you may need to train them through capacity building, and there's many ways of doing capacity building. ICSID does it. Some governments do it. What I found about capacity building is that it's never enough. I mean, it's never enough. There's incredible efforts, and for instance, Colombia has done online training. They have recorded tapes. They have done something similar to what has been done in Singapore, and Jeremy was relating. They have done booklets explaining in a visual and verbal manner what you should not be doing if you have BITs. But it's never enough, and you just have to keep on doing it. And then if of course you are unable to prevent or minimize, the cases will come. At the time when I was director for foreign investment, and for a few years, Colombia had no cases. But of course now it has 17. So the cases will come. And then I really loved the quote from John Wick that Manaz referred to. I didn't know that sci-fi violence was one of your genders, but that's great. So the quote is I think that very appropriate for this type of discussion. And how do you prepare yourself? Well, I believe that in the comments that I have heard here, you have all put together the structure that would be necessary in a set of guidelines. You have referred to there being a need for state lead agency. And by the way, one of the comments from Tim was well, states learn by making mistakes. My first year at ICSID, I received a request for arbitration from a state. It doesn't matter what state it was. That was my first year. And at that stage, I thought, well, they didn't send they didn't reply until many months after the request was sent. They're sort of not really aware of who should be representing the state. There were two ministries, the ministry, let's say, of transportation, and then the Ministry of Foreign Affairs. I said, oh, well, it's reasonable. It's our first case, right? By my third year, another request for arbitration against that same state came. The same mistakes. They still didn't have the state agency that would be representing it. And so the tragedy is that if a lead state agency is not appointed, and it's fairly easy to do, then you're normally in trouble. So that's the importance of the state agency. Then the structure of the guidelines then follow very suggestions, and I'm not going to go through all of those, but there are issues of resources, budgets. I am also not a fan, but I'm strongly opposed against corruption. But one of the misconceptions is that you have to go through open bidding and procurement process to appoint counsel, and that's a huge mistake, because by the time that you're appointing counsel, the case might be over. So that's part of it, or in the middle of the case. So yeah, there might be a need for transparency procedures. Many states are very much developed on that. I can think of Costa Rica. I can think also a bit about Colombia, etc. But that's another aspect of it. The model, you have touched on the model, whether it would be a model of the state defending itself, or a hybrid model, or external counsel. There are various levels of success under those three levels. I'm a kind of strong believer that the state can do it, and that there should be at least some capacity building if they have external counsel, and that unfortunately happens under certain systems. So it doesn't happen under all of them. I would like to sort of close the loop, and I would also invite Chester to share any thoughts of the guidelines that I may have missed. I would like to close the loop by by being thankful specifically to Daniela, who pointed me in the direction of what the discussions at the Ancestral Group 3 are now in terms of capacity building and the need for the advisory center. And the reason why I'm so thankful is because after 4 years since the guidelines were drafted and yet not published, my question is this really relevant again? I mean, is this something that would do any good? And I'm finding myself in front of a lot of statements by various states in the ancestral discussions, just to get to a few of them. They're talking about capacity building. So one of them from the Netherlands, Peru, and Thailand says, following the indication and prioritization of capacity challenges, it will be necessary to consider the models that an assistance mechanism could take in order to help address them. The scoping study surveys a wide variety of models. That assistance mechanism, both with respect to international investment law, as well as those employed in other legal fields, have taken and may take to address various concerns. Models that are explored in depth in the scoping study include institutionalized multi-service support, including legal representation of clients' governments, pro bono, ad hoc, legal and expert support, intergovernmental knowledge sharing hubs, discrete capacity building networks. So both for prevention and for readiness, those suggestions lead me to believe that the idea of a guideline or guidelines are necessary. I would like to sort of jump into a world where there's already an advisory center for investor-state arbitration. I don't know whether it will happen, but let's say that we're there. Part of its mission should be how to train states to create the structure to be ready and to prevent disputes. So I believe that perhaps now more than ever, the guidelines are necessary, and we have received comments from many individuals who have negotiated treaties and 2 defended treaties, defended states in investor-state arbitration, many of whom are seated here. And we're very thankful, and the commitment is to release them as soon as they're revised. Thank you.
Thank you very much, Jose Antonio, and to all the panelists. I suppose just one further thought on the utility of the guidelines is that, in addition to the comments that have already been made and observations that have already been made about government officials and many states not having the right sort of interagency coordination process and not having had the government officials had prior experience in defending investment treaty claims or knowing what to do when the letter arrives through the mail that there's a sort of a notice of dispute, and they're overburdened and working in silos and that sort of thing. But there's also the phenomenon in many governments, certainly those with which I'm familiar with, in that government officials tend to move jobs every 2 or 3 years, and it's part of the government officials' career structure that, in order to progress, they need to have a certain amount of experience in different government departments, and also in order to seek promotion to the next sort of level in the promotion structure, the right opening might not be available within their current department. Therefore, they apply for one in a different government department, and so you find that a government official might spend 3 years working in the Department of Agriculture, 3 years working in the Department of Justice, 3 years working in the Department of Transportation, and so government officials get this incredibly broad and fascinating and varied diet to their career, but that means that expertise, even if it's acquired, is lost to the government department, which is the one which receives the letter. And so the government official who maybe handled the case, maybe Jose Antonio, your experience working at ICSID over a number of years, where that first government official received the first sort of request for arbitration and sort of left it in the bottom drawer and put it underneath their notepads and didn't really do anything with it until it was too late or very late. That person was probably not there 3 years later when the second request for arbitration arrived. There was a new government official. Now that's speaking very much in generalizations. That's not the case in every government, of course, and there are sort of some sub-departments, even within an Attorney General's department or within a Department of Foreign Affairs and Trade, maybe the lawyers stay put, and that's certainly the case in the UK government, where I worked for a number of years in the Foreign and Commonwealth Office. The legal division was really ended up being that was your job, and there were people who had been in the legal division of the Foreign and Commonwealth Office for 30 years. But my sense is that is, and I guess the State Department is also similar. The Office of Legal Affairs works in a similar way. But my experience of a whole range of other governments suggests that there is frequently movement of government officials from one department to another, and that is another challenge for governments to have to confront, which really highlights, I think, it underlines the need for there to be a lead agency which is designated by the government to the proper interagency process for when these letters arrive. Okay, look, I think we have some. Is there any Q&A in the room? I haven't seen any on the chat, but there may be people in the room who wish to make a comment, and maybe Jose Antonio, I'll sort of pass the baton over to you to manage the discussion in the room.
And I think we have one question, and let me. Fred, you are on screen now.
Am I audible?
Yes, you are.
Excellent. I had a question. Wouldn't the states that are more or less oblivious to or neglect to prepare for the ISDS cases also be oblivious to guidelines that are meant to prepare them or prevent ISDS cases? What are some of the mechanisms that we could use to sort of prepare them for the guidelines so that they could be, so that they could get the guidelines? Could it be an idea to attach them to the notice of arbitration, or any thoughts on that?
I mean, anybody, or I mean, I can take it, but
Well,
anybody.
can I just say, the way I envision it, is that at least some of those fixtures that are part of the guidelines, they would become part of the government, right? That they when you give a bureaucrat a job, they'll at least show up in the meetings. So I feel like if you created like the early warning system that it has 5 people from different places, that's going to stick. My bet would be that that's going to stick. So whether or not they read all of the guidelines, I feel like capacity is take it one step at a time and hope that it keeps building. But that's the way I think about the guidelines, sort of a Lego kind of thing you build in there.
And I agree. I would say, depending on what side and what experience you may have, my initial experience was being a civil servant and then representing states, and in my experience, I don't think that as a general rule, I don't think that the civil servants, even of states that have a hard time complying, is a mindset where they're not trying to comply. It's more of the state is a huge multi-headed beast, and coordination is very difficult. And most of the civil servants, they're trying to do their job, and they're trying very hard, and they're working for a salary that is not a very high one, and there's still sort of there's an ethos of commitment to what they're doing, and they might be fully committed, trying to do their best, and they might not see any issue with protecting a domestic investor before a foreign investor. Why? Because it's the local industry. Or there may be other examples, or there might be a measure that might be affecting an investor, but it may have some basis under public purposes, health and environment. So my thinking is, if you provide them the tools of what to do, for them to sort of start getting the house in order, and many have done it. I mean, there's many states for which a significant part of the guidelines would be, oh, we've done this, we've done that, but there's many that haven't. So I think that offering that is a step in the right direction, and ultimately it has to be a sovereign act. You cannot impose it.
So my question is, two parts. First one is regarding some states are now initiating a new mechanism of ombudsman, which I think they're following what the South Korean model is. Is that seen as a more protectionist measure, where before you advance to the stage of arbitration, you first go before this ombudsman mechanism to ensure that, is it like a more preventionist measure, or is it more to do with we should get away with ISDS? Is that what the intention is? And the second part is, since we are having quite a lot of discussions on backlash against ISDS, so do you see a rise in state-to-state dispute resolution, or maybe just going back, as history repeats, diplomatic measures? Because India right now has trying to go away from it, and what we saw in the India-Brazil BIT. So these are the two questions I have.
I don't want to take all the questions. Please jump in.
Maybe Nanas, who spoke about sort of early detection of claims, and the ombudsman is certainly something that I see, like in the Brazil investment cooperation facilitation agreements, sort of a first sort of point of contact for investors to raise grievances with the host state. Manas, I don't know if you
Yes, I think that. Yeah, no, I think that's quite right. I'm not entirely sure which precise mechanism. I think it was Pushkar who asked the question, probably from what I recall, how it would work. But certainly what I had envisaged as part of this aftercare had various levels of escalation. When a dispute arises, sometimes you need a person to investigate the issue, and often this agency, this investment promotion agency, or whatever central entity you had posed the responsibility to, could investigate what, let's say, a port authority had done somewhere, and then try and at least find out what the facts were. And if this ombudsman scheme could, in a sense, help find a resolution, I think that would air out the dispute, if nothing else. Sometimes people want to be heard, believe it or not, and sometimes that occasion doesn't come till the final hearing before the state entities, because there is no talking. But if it's used to deter or delay or hurdle the process, i.e. you've got to go through these various sort of layers, I'm not entirely sure how helpful it would be. I always thought the 6-month cooling off period was precisely the type of place where you would have these mechanisms in place to try and resolve it at home cheaply, without resorting to an investment treaty claim. And that's how I'd see it. Don't know if that helps.
Just to supplement on the ombudsman, I see the ombudsman as an internal sovereign mechanism to attempt to bring some neutrality and assessment, but it remains a state, and I don't think that the adoption of ombudsman where it has been adopted or when it's being thought of, would necessarily move away from the dispute resolution investor state. It may help solving some disputes, like the ombudsman of newspapers. I mean, that sometimes brings some level of neutrality, which I think is what is being tried to be done.
Thank you very much. And just I'm got one eye on the time, and I'm conscious that at least for those of us online, I think the plan is that we would be going to breakout rooms with some of the other online participants for a few minutes. So for the last maybe 5 or 10 minutes of the session. So maybe if there's one more question in the room, that there may not be, but we'll probably have time for one more question before we go into that sort of breakout room function for those of us online, and those of you in the room can mingle with amongst yourselves.
Sure. So I had a question, and it sort of follows from the ombudsman question, and also goes to what Ms. Malik said about the role of national courts. Oftentimes, what we find is there are parallel disputes that sort of run before an investment arbitration forum, but also before a national court if there are issues of corruption. And more often than not, it's the national court which sort of freezes up government activity, because that gets reported in the national newspaper, and the opposition political parties sort of get onto it, and it leads to this domino effect where the government essentially freezes up. So I have a question and a comment. I'm just wondering whether governments might benefit from being before national courts because of judicial review, but the flip side is that once they're before a national court, they have to sort of disclose a whole bunch of things, and then they're sort of being scrutinized on a day-to-day basis, which might sort of freeze them up. But then the question is there perhaps a way for us to think of an ombudsman type body that might first take charge of at least a fact finding within a national system before it becomes part of the public law system, and and the government is then accountable on a daily basis? Would that perhaps help the government prepare sensibly, bring the facts out, and sort of assist it in the investment case as well?
Thanks for the question. I might refer that to one of our two panelists who spent a number of years working with the US government to see if they think that kind of structure would fit within the institutional apparatus of something like the State Department. Jeremy, do you have any thoughts?
Thanks, Chester. Personally, from my experience in practice, I think investors are looking for someone within government to take a dispute before it goes to arbitration, often outside of the line ministry or whatever entity had given rise to the dispute, because at that point, they're at an impasse. So whether it's an ombudsman or something like Peru has with a committee, of interministerial committee, I think it's a very useful thing for states to do, to have a formal process in place that the investor can go to and say, look, we're at the end of the line with Ministry X, and there is an investment treaty in place, and we have rights under that, and we could proceed to arbitration. But really, in order to get our investment back on track, we think the following things are required. And my understanding that some of these states that have these interministerial committees in place, for instance, have avoided a number of disputes. And even if they haven't avoided the disputes, they can give advice to the line ministry, for instance, about the next steps to avoid the problem that Mana has identified with the one-line letter, et cetera, et cetera, et cetera. Your billion-dollar contract is now at an end. So, I mean, I think to Jose Antonio's point, it's a sovereign decision how states want to set these up, but some mechanism in place, excuse me, so we don't go from problem to investment arbitration is really worth having.